Welcome to our presentation on new laws in 2026. Yes, it's June, and it's 2026, and we're just talking about the new laws. Why? Because it takes some time for us to go through them, which we have, and we have a great presentation for you today. Great show. Lots to learn here because we're in a new legislative session, expands for the next 2 years. And we're going to see a lot of new laws. There have been a lot of bills, literally thousands already since 2025 and the session 2025 to 2027. We're going to see thousands more, but not all of them end up becoming new laws. Think about it like a funnel. Still, knowing that thousands of new laws do reduce down into hundreds of important laws, and we're going to be talking about those that might affect you in the trust and estate planning realm. It could be taxes, it could be actual things involved in planning, it could be things involved in administering your trust or estate. We're going to talk about all those things today. This is not a complete guide to all the new laws in 2026. This is the ones that are going to affect you within our trust and estate realm. And of course, I should put my disclaimer hat on. This is only for California. Yes, we're going to be talking about some federal laws that affect everybody, but a majority of the laws we're going to be talking about today are Californian laws. So if you're watching this and you're not in the great state of California, these laws do not apply to your state. So without further ado, here are our new laws for 2026. So what we're going to learn are key legal updates, of course, the actual laws. We're going to see how they're going to protect our loved ones as applied. And what your takeaways are going to be is how you can use those to help you plan for your changing. And maybe you need to change your current plan as a result, or not. That's the whole purpose of getting this knowledge, right? Is to understand, hey, are these new laws going to impact my plan that I might already have in place? Maybe yes, maybe no. So stay tuned. Why don't we start with, I think, what is the most impactful for our seniors? So if you are like me and you have parents that are in their 70s and 80s, or a number of our clients are in the same situation, same boat, because they're in their 40s, 50s, or 60s, and they have parents that are aging. Maybe they don't have both parents, but maybe they have at least one parent or relative who is old enough to be thinking about Medi-Cal, meaning that they need additional care, and they need additional care outside of their home. That's what this law that we're going to be talking about here impacts. So not Medi-Cal as healthcare benefits, not Medi-Cal for in-home support services care, but Medi-Cal as it pertains to nursing home care. Now, nursing home is our colloquial term, when the legal term is skilled nursing facility, or SNF. Some people call it SNF for short. That's the place that people go after they get discharged from a hospital for rehab. So the skilled nursing facilities have dual purposes, and that's why it gets confusing sometimes. Look, I'm going to, or my um, parent is going to a skilled nursing facility. It's not age related necessarily. You just get discharged from the hospital to this place that's an interim between you in the hospital and you at home, hence rehab. So a primary purpose is rehab. So oftentimes these actual placements you'll see on the sign outside, it's a rehab facility or acute care. It doesn't say nursing home. However, the net effect for some people is that they don't get to go home from these places because they're not capable of being able to care for at home. It's not safe at home. Their care has transitioned from rehab to custodial. So now they are there and they need additional skilled nursing along with their custodial care, which they can't get at home, or they can't get elsewhere, and so they stay put. They stay at the acute care. They stay at the rehab facility. But now they transition to becoming a custodial patient, a custodial resident there. And now the Medicare no longer applies. Medicare will pay for your rehab stay up to 100 days. After that, you have to private pay. So anything longer than 100 days in a year is going to be private pay. And if you're not going home and you're in custodial care, now you're in that nursing home component of the skilled nursing facility, and you're paying out of pocket. Except for some people, they might be eligible for Medi-Cal. Medi-Cal, as the healthcare piece, does pay for custodial care in skilled nursing facilities. And Medi-Cal, let's be clear, that's Medicaid. So if you're hearing Medicaid just universally on the news, or reading things in newspapers, or on the internet, Medicaid is what we're talking about. Medi-Cal is California's Medicaid program. Every state has their unique little name that they call their Medicaid program. California's is Medi-Cal, which makes it confusing because it's easy to misspell as medical. It's also easily misunderstood as Medicare. People say Medicaid. Well, when they say Medicaid, it really is, that is what Medi-Cal is. Every state has their own rules, and California has its own special rules as who qualifies for Medi-Cal. And all this lead up to get to this point in the slide is the biggest change for, I think, this year, is that California has reinstituted what we call an asset test. There are thresholds that you have to be under in order to qualify for Medi-Cal for skilled nursing. And again, this is just for Medi-Cal for skilled nursing. So Medi-Cal does come into play for other people and for other reasons. Here we're talking about payment for nursing home care. You cannot have more than $130,000 of assets as an individual, or if you're married, $195,000 of assets. But we'll put a little asterisk in that for a second. Just think about for an individual. So for a number of my clients, they only have one parent living, and so that $130,000 is the mark. That does not include, what is excluded from that, so not included, is a house, their primary residence that they have an intent to return to if they're not currently living there. So if they're in skilled nursing right now, but they have a home that was previously their primary residence, we always say they have an intent to return, so that is not counted. A transportation vehicle, not counted. Irrevocable burial contract, not counted. And a number of different personal property assets, not counted. And also, interestingly, if the applicant or recipient of Medi-Cal has an IRA, 401k, 457B, any sort of qualified account, then they're taking distributions, the mandatory distributions. Most are. We're talking about people that are over the age of 73. Then the principal of those accounts not counted. The rub is, of course, if they're taking distributions, the distributions go right to the state of California. So that's the rub. But if they have, let's say, 300, 400,000 in an IRA, then that's not going to be counted, meaning that they're still technically qualified, doesn't count towards that $130,000 threshold. So if they have a house, primary residence, and 400,000 in an IRA, and maybe a few $1,000s that they get in the bank account from Social Security and some meager savings, they're going to be qualified for Medi-Cal under even this asset test. However, a lot of people aren't going to be qualified because they have a stock portfolio. They have more than the 100,000. And by the way, the primary residence has an upward limit. So most of the homes right now do not surpass the upward limit. So we're not so concerned with that piece of it. But if you have a $2 million home, then you're not going to qualify for Medi-Cal. So that's going to become a growing problem in California as our homes continue to appreciate. So this asset test is real. This asset test is a problem. If you're a couple, you get a little bit extra because you get $65,000 for every adult dependent. So it might not be a spouse. If you are a widow or a widower or just a single older adult, and you have an adult child who is a dependent of yours, maybe they have a disability, special needs adult child and they live with you, you get that extra 65,000, so you have 195,000 there. And if it's a couple with a dependent adult child, then it's 195 plus 65,000. So it's 130,000 plus 65,000 for every dependent. The reality for a married couple, it's a little more. What you're not seeing here is some of the fine details, which is why this is an extremely complicated area of law, is that there is a spousal resource allowance, community spousal resource allowance, CSRA, which is upwards to about $257,000. So the threshold for a married couple, just think about it, it's probably about double of what the 130,000 is. But there's still a cap, and that's still going to be problematic because for the last 2 years, 2025 and 2024, there was no asset test, zero. So you could have literally billions of dollars in assets and qualify on the for Medi-Cal. Now, if you're having billions of dollars of assets, you probably have a lot of income, which would make Medi-Cal just not make sense. You wouldn't qualify on the income side of things. So this is not an income test. It's just an asset test. There's no grandfathering. So if you know somebody that was got in the last couple of years or before for Medi-Cal, or especially the last 2 years when there was no asset test, and they've been receiving Medi-Cal and they're in skilled nursing, this new law affects that. So now there's a good chance they might not be qualified and not realize it yet. And so what's going to happen is when they have to send in the redetermination forms, Medi-Cal is going to say, you're not qualified and you're going to owe us payments from January 1st of 2026 forward because there's a lag. January 1st happened. That's when this new law went into effect. But no notices went out saying you're no longer qualified. They continue to make those payments if Medi-Cal was paying for people previous to this year. And so just keep paying until Medi-Cal realizes that they're no longer qualified. How they realize? In Medi-Cal, you have to send in a redetermination form. Usually that's once a year. They've been talking about increasing that to twice a year. But there's a document you're going to have to send in, and that will be processed. And at some point this year, they're going to realize for those people that went in and got Medi-Cal when there wasn't an asset test, and they're currently over the threshold now, Medi-Cal is going to say, hey, you're now no longer qualified. We're no longer going to be paying for the skilled nursing facility, and you got to pay us back for all the months in 2026 that we paid before we realized that we didn't have to. So this is a big problem for a number of people. It's a time bomb waiting to explode that we have to get in front of. Fortunately, there are solutions, and so you need to talk to a qualified elder law attorney for those solutions. Fortunately, that's what we are here at Snyder Law. It's one of our areas of expertise. Elder law is helping those plan to qualify for Medi-Cal or crisis planning to remain qualified for Medi-Cal in these particular situations. So I spent a lot of time here because this is the most significant change for 2026. But let's talk about some others. Let's talk about gifts. If you remember nothing from this presentation, remember this. The federal government has given you a gift card worth $15 million. That means you get to make gifts in your life or death up to $15 million without paying any gift taxes. That's right. You have this theoretical gift card that you can use to make gifts to people while you're alive, and the IRS deducts from that gift card just like a regular gift card. They swipe it, and then you have $15 million less whatever gifts you made during life, and the remainder of that balance in the gift card is then applied to the gifts you make at death. We call those inheritances, or in some fancy law books, bequests. And the gift card applies to that. So if you are making less than $15 million of gifts during your lifetime, and this is in the aggregate, so it's not 15 million during life and 15 million after death, it's 15 million total. If you make less than that, there's not going to be any gift tax. The rub is that you have to report some of those gifts to the IRS, hence the swiping. So when do you swipe your gift card with the IRS? Well, you swipe it when you're making a gift more than $19,000 a year to single person. So if you want to make a gift of $20,000 to a grandchild, you have to swipe your card to the IRS that year. How we swipe is we fill out a document called a 709 gift tax return. And you do that with your accountant, and they submit that with your regular 1040 returns. And the IRS keeps a log, and it says, all right, the 709 tells us they made X amount of gifts that year to this person, and they deduct that over your total amount of gifts. So it's a ledger, and at the end of your life, then the IRS will see how much you have left in your gifting. What is your gifting power at death? So that's how it works. Now, if you are over that amount, meaning that usually the situation is that you have an estate that's larger than $15 million. You made a bunch of gifts, and then you don't have enough money on your gift card left to gift away your entire estate without being taxed. So in other words, whatever's on that gift card, whether, hey, I didn't make any reportable gifts for my life, I have $15 million. And if my estate's worth more than $15 million, then my estate's going to be taxed by Uncle Sam. The tax is high, it's 40%. It's 40% on the amount over 15 million. That's still high. So think about it. That's if you have a $16 million estate, you made no reportable gifts in your life. That means, and you can apply the $15 million gift card swipe. It means you have $1 million that's taxable in your estate. That's $400,000. It's a $400,000 tax that the IRS is going to require within 9 months. No questions asked, no continuances, extensions, nothing. You owe that money. So, and that comes off the top before any of your beneficiaries receive anything. And that problem just grows with the largesse of an estate over that $15 million. For a married couple, good news is husband and spouses get to combine their $15 million. So it's really, for a married couple, looking at an estate of over $30 million for there to be a problem. And so what do we need to be thinking about for those of us that have larger estates? Then when we're approaching that 30 million, if we have a married couple, or 15 million an individual, not waiting until we actually hit that number or go over it, but as we're approaching it, because if we think, well, if we live for a little while longer, we're definitely going to be over that when we die, is to put some good advanced planning in place. And the advanced planning doesn't happen as quickly as setting up a revocable trust, so you have to have some good lead time in front of that. That's why you have to start that planning earlier before you hit the actual 15 million and 30 million threshold. Last piece of good news in here is that number will adjust annually for inflation. So next year it will be 15 million and change. So it'll probably be like 15.99 maybe, or 15.45. It depends on what the inflation rate is. And if it's really high, maybe it'll go into 16, but it'll adjust every year upwards a little bit. So that's really good because we have some bona fide rules. There's no sunset provisions into the law now. The One Big Beautiful Bill didn't make this very clear. And so for right now, this is the law. So that's helpful to know. We don't have to worry about any sunsetting in the future of the law. Now the law may change, of course, but we'll have to deal with that as it comes. Okay, so the next important law, I think, so this is like the number 3, and I put these first three slides in order of importance, because this affects probate, and it affects a lot more people in California. And answering the question, do I need a trust, or do I just need a will? Do I need a will, or do I need a trust? And the bottom line is that if you have assets more than this threshold here, which is now $239,700, so if it's more than that, then you need a trust. So you can have a will in California, but if you have a will and assets over this threshold, then your estate is still going through probate court, still subjected to the same long timeline. We're talking a year and a half or more. Same statutory fees to the attorney, which is and the executor, all combined about roughly 5% of your fair market value. even though you had a will, because your estate was over this threshold. So many people in California have an estate assets that are exceeding this threshold. Why? Because many people own real estate, just to start. So that's easy. And just even one parcel of real estate, just your home, is going to be worth more than this. Now, from last year, there was a law that was passed that said if your primary residence is $750,000 of fair market value or less, then that property is not going to pass through a full probate. There'll be a mini probate and some documents that can be filed that'd be like probate light, but it won't have to go through a full probate if there is no trust. So for those that had a home that's under $750,000, you might not need a full trust. A will might be okay. We have to look at what your other assets are, of course. But that was put into place it was an attempt to help people, at least their families, not to alleviate the probate problem and to clear the probate docket, because a lot of people still aren't doing their estate planning, and the probate dockets are getting filled with these properties. These estates are just basically one property, one home that's 500,000, 600,000. So they picked that level to try to capture a lot of those probates in hopes that they wouldn't be clogging the docket. Now, the rub is that there's still a court procedure for that. There's still a court for that, so it's on somebody's docket. And that means that it's not going to happen quickly, because getting a court date is not easy in any county. In Orange County, I could tell you, it'd be easy 4 to 6 months to get on calendar if you filed for a petition for something even short. That is 4 to 6 month wait. So we're still talking wait. So it's still a good idea, if you have real estate, no matter what its value, to have a trust. But this number, it did go up. It only went up a little bit, though. So the previous number was $184,500. Before that, it was $166,250, I believe. So this threshold doesn't go up very, very much, and it only applies to for decedent estates. So people's estates that died after April 1st. For some reason, with this threshold, they always pick April 1st. So it's April 1st, 2026. If they died in 2026, but it was March, February, well, then the old number applies. And that could be significant for people. Think about it. If there was only like a bank account in your grandfather's name, and it had $190,000 in it, but the grandfather died February 15th of 2026. Well, that account's going to be frozen until it goes through a full probate. If grandpa died with just a will or no estate planning. But if grandpa had died April 15th, that would not have been a problem. It would have been something that could have passed through with just paperwork with the bank. So dates are also important. Moving on to something that's pretty cool, especially for those that have utilized the college savings accounts, really educational savings accounts that we call 529 accounts. Now, under California, we can use those as an asset protection tool. It's an added benefit, and the legislature did this in order to encourage the use of California's state-sponsored 529 program called the Golden State Scholarship. So this isn't for all 529s. It's just if your 529 is the Golden State Scholarship Program, which is the California state-sponsored 529, then you get asset protection with that, which is pretty cool. So I don't know if you get that in Ohio or Illinois. And remember, you don't have to be residents of those states to utilize those state-sponsored 529 accounts. There are all sorts of different benefits, and you can forum shop. You can shop which state you think works best. And so this is just another benefit California put into place. Say, hey, come shop with us, and you get this asset protection. So technically, you can be an out-of-state resident and utilizing 529 accounts through the Golden State Scholarship and get the asset protection. And the asset protection is over the assets, of course, in the 529 account, meaning if you got sued, then those assets aren't assets that can be taken in some sort of monetary judgment, either by you or by the beneficiary of the account. So the rule is that money has to be in there for at least 2 years. So anything that has been in there for 2 years is protected. Within the 2 years, then only the annual contributions. So it can be, the annual contributions tax free is 19,000. I think the actual 529 one is 20,000. But the point is that there's a cap per year. So only the amount that you made that year would be protected, and then everything that had been there for 2 years or more would be protected. So great tool, built-in asset protection. It is akin to the type of asset protection that is provided by the RISA laws federally for 401ks, for example. You can't lose your 401k in a lawsuit because the federal laws have built-in asset protection. Similar concept to that. Really good, really awesome. Here's an interesting law that was passed in regards to unclaimed property. And this is digital financial assets. Whoa, what are digital financial assets? We're really talking about Bitcoin or cryptocurrency. So whether it's Bitcoin, Ethereum, or all the host of other ones that have come up, we're talking about crypto assets, and they can be unclaimed when someone passes away, right? There's the keys lost, and nobody knows how to get a hold of it, or nobody knew that the person owned it, for example. It's on an exchange, it's listed somewhere, but nobody knew about it, so it's lost. Well, that technically goes to unclaimed property, and any of these exchanges that have these unclaimed property have to report it to California. So it has to be reported to the state controller within a certain period of time, and then the state controller has to liquidate that, turn it from its form of cryptocurrency into cash within 18 to 20 months. And the reason why they were doing this is because, of course, this is a volatile market, right? So those crypto assets might have value that changes quickly. And so they wanted to make sure that they were protecting the value of those assets at the time in which they became unclaimed. So not holding it forever and then maybe it's lost value, and then someone could claim that the state's liable for it losing value. So you just have to liquidate that. If it wasn't such a volatile market, I think it might be different because the state controller also holds unclaimed property that a lot of people have, which are rebate checks, for example, or money judgments that you didn't get notice of, or the notice never reached you, got lost in the mail. You can go on the state controller's website and check and run your name, and you might find that there's unclaimed property there that you can now claim. I do this at least once a year. Interestingly, I do it on St. Patrick's Day, and kind of the theme of the pot at the end of the gold at the end of the rainbow. I'm going to cash in. So I run my name, my wife's name, and see if there's any unclaimed property there for us. And some years, nothing. Some years, a couple bucks. Some years, a few $100s. And so it's an important thing to do. And it's something that we do, of course, with every probate or every trust administration. We run to make the search through the unclaimed property to make sure that we're helping the trustee or executor claim that unclaimed property that belonged to the decedent. So, but now it's going to include crypto assets. This slide is to prime you for an important case that was just decided and released about 2 weeks ago. And it involved what we call the anti-lapse statute in California. What that means is that the law says that if you have given a gift to a beneficiary, think about it, a parent has gifted at death through their will, their trust, an inheritance to their child. That child also has children. But before the grandparents died, their child died before them. They predeceased. And then grandparents pass away without updating their planning. Does the child's share pass to the grandchildren, i.e. the child's children? And the law in California says yes. The presumption is yes, that even without saying that, that child share would be presumed to pass to their own children, their descendants. So when we gift to somebody, it stays within their line of descendancy unless we clearly express that we want it to lapse. And we use that language in our will or trust that upon if this beneficiary predeceases the creator of the will, the creator of the trust, then this is the result. And as long as we're clearly expressing that, that result can be contrary to the presumption. It could be that we say, oh, I just leave this inheritance to my adult child. If they predecease me, no, I don't want it to go to their children for whatever reason. Maybe I don't like their children, I don't have a relationship with their children, or the children are bad news. Instead, I want it to go to the spouse of my child, to charity, to my other children that survived me. Whatever the situation or reason might be, as long as you're expressly including that language, then the anti-lapse rule doesn't apply. But if there's no language about it, the law says, hey, we got you. We know that the presumption generally would be, hey, I'm going to leave this to my child, and then if they predecease me, I want it to go to their children. I want to keep it within the family line. And that's the true, no matter if it's a child, it's to your sibling, and you want it to go to your nieces and nephews if your sibling predeceased you. That's kind of the order of things California is saying. We understand that's the presumption. But hey, look, if you don't like that built-in type of a plan, then you just tell us clearly in your will or trust, and we'll honor that. And so it's important to recognize, because this case that just was decided in re tongue, 2026, literally a couple weeks ago. This is hot off the press, people. The situation is here on the slide. It wasn't very clear from the trust whether or not whether the tongue, Ms. Tongue wanted, the mom in this case wanted something alternate than what the California anti-lapse law said. So, the son died before mom, leaving 3 kids. And there was 2 sons, and the other son survived mom. The other son was saying, well, no, I'm the only surviving heir to mom, so I should get everything in mom's trust. It does not go to my nieces and nephews. It does not go to my brother's children. It all goes to me. And of course, the decedent's grandchildren, the 3 surviving grandchildren, were saying, wait a minute, just because our father died doesn't mean that we're out an inheritance. We should inherit his share. That's fair. Grandma left half to our dad and half to our uncle. So uncle gets his half. We should get, I think in here there was 3 sons actually. So it was a third, a third, a third. Uncle wanted it all. But at the end of the day, the trial court ruled for uncle, but the Court of Appeal reversed, saying, wait a minute, anti-lapse in California says you have to clearly state an alternate result. Otherwise, the anti-lapse rule applies. And here we don't see clear enough language in the trust for an alternate result. So the anti-lapse rule applies, and the decedent's son's children do inherit his 1/3. So as it ended out, 3 sons, 1 died. That son who died, his 3 kids get his 1/3 share. So essentially, the grandchildren each got a 1/9 of the grandmother's trust, and the other 2/3 went to the other 2 sons. Interesting little coda. One of the other sons also died but did not have children, so that 1/3 share did go to the sole surviving son. So the uncle got 2/3 instead of 3/3. In other words, instead of 100%, he got 66.6667%. Right? So he was arguing over a third. Now, it didn't reveal the actual dollar figure, so we don't know if this was a multi-million-dollar estate or less, but it seems to me that the right result here happened. The uncle maybe was a little greedy in wanting the whole pie instead of just accepting 2/3, and end up having to pay quite a pretty penny, I'm sure, for all the litigation between it going to trial and then on appeal. having to deal with that, because for sure the uncle ended up not only having not had to pay money, had to pay his lawyer, and also pay the grandchildren's lawyer, something that we called attorney's fees. So it was an expensive argument to make at the end of the day, and I'd be curious to know, like, how much was it worth it? Was it worth all of that? Because if there wasn't a fractured relationship before, there surely is in the family. So it's important. The lesson out of this is to be very clear in your estate planning. And what was not said in the slide, or it was that the mom had an old trust that was not updated. So a really great call out here to update your trust, because it might not have the right language, right? All right. So something more advanced, something for our larger estates, something for those that have big liquidity events. So think about business owners that are selling a business. Think about cashing in on a big stock portfolio, getting bought out, like I said, on a business. You have a lot of shares as an employee and you're getting bought out by private equity. You're coming into a liquidity event. And this slide is for you. Used to be back in the day, not that long ago, but we'll just call it back in the day, kind of like Star Wars, right? In a land far, far away, a long time ago, um, there was an opportunity to set up a special irrevocable trust, and it was called the Incomplete Non-Grantor Gifting Trust, hence the ING. So not ING Bank, no relationship to ING Bank, but Incomplete Non-Grantor Gift Trust, in trust. And it was also very popular in Nevada. So we called them Ning Trust for Nevada Incomplete Non-Grantor Gift Trust. And then Wyoming got involved. And then it was Wing Trust. And then Delaware got involved. It was Ding Trust. So we had Ning, Wing, and Ding Trust. It was crazy. We had like wings, dings, and nings. And those were popular trusts because you can still be a California resident. You can shift the assets that are about to be liquidated, or have some sort of liquidity event. There would be a taxable event, and we could put those into a trust out of state in Nevada, for example, and then there would be that tax triggering event normally, but you wouldn't be subjected to California tax. So the California income tax wouldn't apply, even though you're a California resident, because those assets were being held in a non-grantor trust in another state. So that was a super great way to save 13.33%, because that's the California income tax rate, which applies equally to capital gains. So it doesn't matter whether we're talking about income from earned income, we're talking about from a capital gain perspective. 13.33% is what it is in California. We're not talking about the federal side. The federal side is still going to impose a capital gains tax, but we're looking at saving 13.33%. So if we're talking about large numbers, that's a great percentage. Heck, even $100 is great to save $13.33, right? So that's what those trusts were for. Then California got wise, and the legislature said, you can't do that. We're going to create a law. This was a few years ago. Says that's not valid anymore. You cannot be a California resident and basically offshore or out of state, put your assets out of state in a special trust out of state and take advantage of those estate tax laws like Nevada that does not have an income tax, in order to avoid the California taxes. Obviously, the Franchise Tax Board was realizing they were losing money, and they changed the law to disallow you to participate in this type of program. So that's why this slide is super important, because it's saying, wait a minute, we're going to carve out an exception, and we're going to put it in the law. And the reason why the legislature had to do this, because I'll tell you, California legislators didn't just do this because they thought it was a good idea. It grew out of what the Franchise Tax Board was saying, how it was already going to apply it. So this was something that was kind of already being applied off book, and essentially the legislature said, well, we're going to now make it on book. We're going to make it a law that's clear. So It's not just we're going off of prior practice or some opinion letter from franchise tax board. So now the law is that same deal. You can't offshore the assets into Nevada or Wyoming or Delaware and these other trusts, except if it's for a charitable remainder trust. Meaning that if you are donating to charity, essentially, if your trust, the residual of this trust is going to go to charity upon your death, hey, we want to encourage that. Have at it. Do that. We will allow you to do that so that there's not a taxable event if, hey, I'm going to put my big portfolio into this trust, the Ning trust. I'm going to do it in Nevada. I'm going to put it in a Ning trust, and there's this big portfolio, and we're going to sell it all off. I want to save 13.33% on that portfolio because eventually it's all going to go to charity. So I'm going to try to save that charity all that money. Hey, that's great. We're going to do that, and it really works also for large large real estate portfolios as well. If you so anyway, anything with a that has appreciating assets, it's a good strategy still if the residuals of those assets when you pass away are going to go to charity. It's called charitable remainder trust. We're going to allow that, so you can do that. Why this is important is because if you are back to our first slide, if you are an individual with close to or over $15 million estate and you're worried about the estate tax after you die, or you're a married couple with close to 30 or over $30 million and worried about estate tax for your family after you die, then some of the types of strategic planning involve charitable remainder trusts if you're charitably inclined. So we can actually use the charitable remainder trust and park them in a state like Nevada and also take advantage of their zero state income tax. That might be beneficial. So hey, these for limited reason, these Ing trusts are back on the table for California residents. Now, moving to something that's really near and dear to my heart and my practice on the litigation side of our practice is combating elder financial abuse. And this has been rampant, just absolutely rampant, particularly on the title side. It's unbelievable the stories that if you were to start deep diving in the internet, you will find in regards to title fraud. People are going in and taking mortgages out on people's homes, and those people have no idea, or they're actually selling the property, and the people have no idea, the true owners. It's unbelievable that this fraud is occurring right now, and to combat that fraud, some counties have gone ahead and say, hey, if we get a deed recorded, whether that's a grant deed, a quitclaim deed, it's a deed of trust for a mortgage, we're going to send a notice out within 30 days to the titled owner to notify them that there's been some activity in regards to their title, and to combat fraud, because you get this notice, you're like, hey, what happened? I didn't do this. Then you can start taking action sooner than later. And it was a hodgepodge. Not all counties were doing it. So this is a statewide law saying effective January 1. Now, I don't know why it wasn't effective this year. The law was passed 2025. Why it wasn't effective immediately, but I think they were giving some time for the counties that didn't have a program to give them a year to get the program in place to get these notices out. Hey, by January 1, statewide, there's going to be notices that are sent to the title owners if there's been some activity, and that notice goes out within 30 days of the recording. So this is a good thing. So statewide. Now, if you're in LA, you're in Orange County, you're in Riverside, this has already been happening. So you've been already getting these notices, which is a good thing. So this is a really good law to help at least notify somebody that something's happened. Now, the fraud's already occurred. So you got to go fix the problem. So this law is not fixing the problem. It's notifying you that there is a problem, so you have time in which to fix it before the problem just gets worse because there's been non-payment to a lender and they're trying to foreclose on your property, or you passed away and now your family's dealing with this problem. So it's giving information and notice earlier, which is good. Then you are responsible for acting on that to fix the issue. So don't forget that piece. And the state's not going to fix it for you. The county's not going to fix it for you. You're going to have to go to a qualified attorney that handles this type of real estate fraud. And it could be a real estate lawyer. It could be an estate lawyer that handles litigation, like an elder law attorney that handles litigation. And we're both. So we handle elder law, we handle estate litigation, elder financial abuse, and this title fraud is right up our alley. So that's the type of attorney or law firm you're looking for to help you if you get this notice in the mail and you're like, there's been some fraud in my title because I didn't take out this loan or I didn't convey my deed to somebody, then you need to take action quickly. Also in the area of elder abuse, and sad that we have to talk about this, but I'm in the business of talking about hard things, talking about things that are real, talking about things that are happening, even if they are squeamish, we're squeamish about it, or things not nice to talk about. You're like, that happens? That's crazy. Yes, elder financial abuse happens. Elder abuse happens. Sadly, family members take advantage of their parents or grandparents or other older senior relatives for leverage to get access to their money, for some sort of power play in an argument with siblings. I've seen it a lot, so the pawn in all of that is the senior. And as a way to combat that, California law has allowed and come up with a restraining order that's not a civil restraining order, it's not a domestic violence restraining order. It's a very specific elder abuse restraining order. So a specific section of the Welfare and Institution Code created elder abuse restraining orders. And they act like any restraining order in the sense that you can move to keep somebody away from the senior, saying, hey, you're a bad actor. You're taking advantage of mom, dad, grandma, grandpa, and you need to stay away from them. And we want the court to order you to stay away from them because you're physically abusing them, you're stealing their money. The other part of that is saying, well, on the isolation side, it's not necessarily a restraining order. You're asking the court for an order. We call it an injunction. That's the fancy legal word. We're asking for an order that says, stop, cease and desist, stop keeping our mom, dad, grandma, grandpa, or older relative isolated. Stop keeping them away from us. You have to allow us to see them. You have to allow us to talk to them. That's the other half of the elder abuse restraining order, because there's a lot of situations where a family member, bad actor, has captured the king or queen, and now they've cut off communication. You can't reach them by phone because they're not picking up their phone, or the cell phone's been disconnected. They're not letting you in the house, so they're isolating that person. And you're saying, no, you can't do that. In the court, you have to. This is you asking the court to have an order issued saying that you can't do that. Now, the challenge is that now as we've gone on in the modern day, people live all over the place. Right? It's not just, hey, we all live very close in California even, or in the same county. No one's down the street anymore. We're spread out amongst the United States or internationally. But yet we still want to be able to protect mom, dad, grandma, grandpa from these orders. It's not as easy of getting to that court in person. And previous to this, the courts would say for these restraining orders, we want to see butts in seats. We're going to have a hearing. The judge, it's not a jury, it's a judge, a court trial. The restraining orders, essentially, it's in front of a judge. And so the judge is a trier of fact, but the judge wants to see the whites of people's eyes so they can judge their character, whether they're lying. A lot easier if you're in person, and no disagreement here, right? It is a lot easier to make those judgment calls when you are listening and watching somebody testify on a witness stand versus on a screen in the courtroom. Even when the screen, and I'll tell you, the screens in the courtrooms are huge. In there, you might not. People don't necessarily that don't go to court all the time don't realize this. There is like a movie screen in there. Most of these courtrooms. And so when you're zooming in, when your case is called, your face is really big in there. Even in those situations, they can see you and see the whites of your eyes. There's something's lost in the digital translation, right? So they require butts and seats. And this law is saying, hey, look, we're in now the 21st century. We recognize that people are all over the place. It would be a disincentive to following through with their restraining order if they realize, well, I live in another state and I'm not going to be able to get to California. I can't afford to get to California. So they don't pursue an otherwise valid restraining order, and to the detriment of the senior. So saying, hey, look, we're going to permit electronic filing. We're going to permit remote hearings. We can't have rules, court rules that say we don't do remote hearings. We don't do remote testimony. And kind of the biggest thing, and if you go to court on these and you're in this any restraining order court, a lot of people end up try to do these pro per, and the biggest issue is getting people served. Evading service is big in this. Well, if you can't catch me to serve me, then I don't have to go to court in this hearing. And it costs money to get a process server, and it oftentimes is very expensive. And you can utilize the sheriff's department, but the sheriff's department will charge you unless you qualify for a fee waiver. And the law said, forget all that. We're just going to say that we're going to have no cost services. And special circumstances, if you can prove that there's been an evasion of service, in addition to the normal fee waiver, to utilize law enforcement to serve these, that is an option. And on that evasion of service, I'm going to flip through a slide because it represents, it connects with this. So on service of process, the law is also recognizing that there's been issues with just serving people, and that delays the actual litigation. And so, people can't be found or don't want to be found. So now they incorporate this kind of idea of reasonable diligence. So it's strengthened the definition of reasonable diligence, so you can show if you've been trying to serve somebody and they're just either evading or they can't be found, that it still allows you to move forward, and it spells out how you can use photos, pictures to show all the attempts that you made in addition to declaration. So you don't actually end up having to physically serve someone. Someone can't get away from you in a restraining order case, or some other, if you're trying to sue the trustee, or you need to notify a beneficiary, that it's not, you don't have these long delays because you can't find somebody. They've provided some options. And within this reasonable diligence, you might be able to use other electronic service methods when we can't, if it requires personal service, meaning you have to actually physically serve someone. If you've shown reasonable due diligence, you might be able to use email, for example, in certain situations. So that's helpful. The court was recognizing these issues that come up in things like elder abuse restraining orders. Now, also with seniors in this area of how the law has changed with in elder law, is patient visitation rights. So this is really, really important when we have seniors that are at assisted living, they're at skilled nursing, they're at boarding cares. And who is it that can come see them? The law is saying, look, if the patient, or i.e. resident, wants to see somebody, then it doesn't matter if there's a conservator or someone who's power of attorney or someone who's the trustee of the trust. It doesn't matter if the patient or resident has been deemed incapacitated by the best doctor in the world. If that person, that patient or resident, wants to see somebody else, they get to see that person. The facility cannot prevent that person from seeing them, as long as the patient or resident says, I want to see that person. Conversely, that patient or resident can say, I don't want to see that person, and then the facility has to comply. Even if that is the best person in the world, it's their spouse, who's the kindest, gentlest spouse in the world, then that they can't let that spouse see the patient or resident in that situation. The only caveat here is if there is evidence that family, friends, or other person has ulterior motives that are going to be harmful to the patient or resident, either physically or financially, then the assisted living, skilled nursing, boarding care does not have to let them see the patient or resident, even if the patient or resident says, yeah, I want to see them. My example, is dad has dementia and dad's son is a ne'er-do-well, a bad person. He's going to come harm dad to get back at him for some grievance from years past. And the people working at the assisted living catch wind of that because they hear him talking or there's some evidence and they know that he's going to come in and harm dad. It doesn't matter. It says, Dad, I want to see my son. They can block access. Or if they know that they've seen that son come and see dad with a checkbook in the past and they see dad writing checks and they know dad has dementia, they have strong suspicion that son who has not presented them with any sort of power of attorney or anything is maybe stealing dad's money. They can say, no, we're not letting you in to see dad. So he can write checks to you for money that you're basically taking from him. So there's some leeway for the assisted living, boarding care, skilled nursing to intercede on the to protect the resident. But this is really helpful for those situations where we have family members who are saying, I have power of attorney and you can't see dad because I'm power of attorney and dad's been diagnosed and we have the opinion letter says that he doesn't have capacity anymore and I'm in charge. We're preventing those situations as long as the parent says, I want to see whoever it is. So important thing to know. And the last thing is this is already a federal regulation. So that affects those places that get federal money. So skilled nursing facilities that take Medi-Cal already had this regulation on the books. But this is a state law. So all of our assisted livings, boarding cares that aren't accepting federal dollars through CalAIM or the assisted living waiver program, they now have to comply with what is a corollary federal law. So now just think any place that our seniors are at that's not home, they have to listen for the most part, except for our danger situations. They have to listen to the senior and who the senior wants to visit them. This law extends caregiver authorization rights to certain relatives for certain permission and consents as it relates to minors. So this helps like in situations where there's been a death of parents and we're still maybe going through guardianship process, but we have some other family members that can consent to medical procedures or enrollment in school without there being a guardianship that has been fully granted, because these guardianship proceedings take a long time. It could take close to a year before there's a full guardianship granted sometimes. And of course, doctor's appointments come up, there's the school to enroll in, and if the parents aren't alive or able to enroll or are there to admit to a doctor's care, then that's not happening. So this is alleviating that in those situations. And also in the situations where we have minor beneficiaries used to have to go get a guardian ad litem appointed, which is a neutral professional, usually an attorney that the court would appoint to act on behalf of the minor child to make sure the minor child was their rights weren't being violated or they weren't being exploited. And so instead, now the law is saying, hey, we can have other adults do that, like a parent. So let's say a grandparent leaves inheritance to a grandchild. The grandchild is a minor. Well, if that grandchild's parent is alive, that parent could act as the pseudo guardian ad litem. We don't have to file something in court to have a court appoint a guardian ad litem and have this whole lengthy and expensive process, because that causes unnecessary delays a lot of times. Now, it doesn't take away the guardian ad litem at all. So if it is necessary to have a guardian ad litem because we don't have responsible adults, in my example, the parents are not great parents, they have addiction problems, they're abusive, whatever the situation is, we can still insert a guardian ad litem. Or it might be necessary because there are no parents, they've passed away, and it's just a gift from the grandparents to the minor grandchildren. We can still intercede and get a guardian ad litem appointed. So it does not do away with guardian ad litems, it just allows us an opportunity not to have to use them in situations, a lot of other situations where we have responsible people that can act. Or it also comes up when we can't find people. So, hey, mom, dad died and left it to their 5 children, but that 4 of the children, we know where they are, but that 5th one, we have no idea. It's estranged from the family, has been roaming around God's great earth. We don't even know if they're alive or not. And it's going to hold up the administration of the trust entirely and we have to show that we've done all this due diligence to find them. We might be able to take some actions without that person. Not to take their distribution, but maybe we can still not hold up the distributions to the other children, beneficiaries, simply because we can't find that one. We'll kind of hold their distribution out in abeyance and go through the process of trying to find them. But previously, the entire administration's held up for a long time. So this law alleviates those situations. Getting down to a couple of the last ones here, just so you know, civil discovery, I think this is important just for people to know in general, used to be this morass. You end up in discovery for years, and there'd be battles and discovery, and you hear all these evils of discovery, meaning, we were asking, the plaintiff asked for information, the defendants asked for information from the other side, and there's all sorts of games that lawyers play, strategic ones that are important, and some of them are just for pure gamemanship or not important. All of it clogs the system, and it just becomes years and years of dealing with discovery. And so the legislature said, we're going to streamline this and make it really fast. Basically, show us what you got. Show us what you got. Have you ever seen the movie My Cousin Vinny? And cousin Vinny comes home back to the motel and is talking to his fiance, Marissa Tomei. He's got this box. He says, he just gave me this stuff. Well, in criminal law, you have to do that. So it's already more streamlined. Not to say there aren't issues in criminal law with production of discovery, but it's a lot more streamlined. And the civil side is trying to replicate that to be more streamlined. Hey, within 60 days, if there's a request, you got to show them everything that you believe you have that makes your case, that makes your plaintiff case, that makes your defense. And so that shortens the length of these litigations, was the concept. We already talked about the SPARE Act, the summons, and I think that's our last slide. This has to do with foreclosures. I started with a really important law. This is that's not going to affect everybody, but I think the impact, if it does affect you, is really important because it transfers the power that the mortgage lenders have from the mortgage lenders who used to have all the power back to the owners of the property a little bit. Because before, if you landed in foreclosure, basically the lender could pick a date, and that's the foreclosure date. And if you can't if you can't come up with the money to pay off the loan, or sell the property essentially to pay off the loan, or otherwise come up with a loan, we're going to now sell your house, and we get all the money from the sale. You get nothing. And the laws protected that from this non-judicial foreclosure situation. So they can do that within 90 days. And they picked there was no way to postpone it except to kind of court the lender and get them to voluntarily agree to extend out the foreclosure sale. You had to court the lender, do a little song and dance, proverbially take them out to dinner, make them feel really nice, that sort of stuff. And if you got a lender that just was very straight and narrow, hey, you're not going to move us for anything, they weren't going to extend out those dates. So people lost homes because they just didn't have time to sell it. The foreclosure date came up too fast. They couldn't sell the house fast enough. They couldn't come up with the money, so they lost the property. So the California legislature said, hey, look, we're going to mandate a 45-day continuance of the foreclosure sale if the homeowner can show that there has been a listing agreement that has been signed with a realtor to sell the house. So automatically, boom, you get another 45 days continuance of whatever the foreclosure sale day was going to be. And then you get another 45-day extension if you can show that there's been a purchase and sale agreement that's been signed. And it's like if the house goes into escrow, great, you get another 45 days. So there's 2 45-day built-in mandatory extensions, so a 90-day extension total if the timing works out that way. On the foreclosure sale, this gives better results in that Sure, the property's still getting sold, but the loan's getting paid off, and then the former owner of the property isn't losing all of their equity. So that's what the law is trying to protect, some of the equity that was earned, because it was becoming unfair. Like, you could have somebody who owned a house for 20 years, a lot of equity, more equity. They had more equity than they owed, but they're losing their home and their equity to pay off a loan. And so essentially, they lost more than what they owed on the house. So that was a big problem. This is very new, and so I mean, it is technically a year old, but the law, but lenders are still learning about it. There are specific notice requirements in this, so it's not just automatic. I email you the listing agreement, therefore I get automatic 45-day extension. No, there's specific notice provisions of using U.S. mail. So you got to look at the law, you got to look at the notice provisions, because these lenders are going to be ticky-tack about it, because they want that property sold. They want to get their loan paid off right quick, and they don't want any extensions and having stuff go on forever. They want to clear their books. The longer that the loan's not paid on their books, they're losing money. But take advantage of this. So if this might apply to you, someone you know, somebody you hear, hey, we're facing foreclosure, or you are a realtor or know a realtor, this is something that the realtors should know, certainly. Um, we come to the end of our presentation. I know you stuck with me this whole time, and I really appreciate it. There's a lot of great stuff here. You can tell I'm really passionate about the law, passionate about sharing with you, not just, hey, this is what the law would change, but a little bit of lead up, perhaps, for you to understand the importance of the change in the law, or maybe why the law changed, so you can see how it might affect you or a loved one. So thanks for attending. Thanks for sticking with me. And if this is helpful for you, wonderful. Please pass it on. It'll probably be helpful for somebody else too. Please share our link. We're probably watching this on our hosted YouTube link. Please share this with as many people as you know, because knowledge is power. And once we have the knowledge, of course, the second part is what we do with it. And we're here to help you with that piece, or help those that you know. I'm Kevin Snyder of Snyder Law. I'm an estate planning, probate, and estate litigation attorney of Snyder Law. We're a California-based firm. We have offices in Irvine, Pasadena, San Jose, and up in Contra Costa County. And we look forward to helping you where we can. In the meantime, keep being amazing. Thanks so much.